Alright, so let's start with infidelity of public officers. We still are on the chapter of crimes committed by public officers, right? So this one is chapter 5, infidelity of public officers. What are the crimes classified under infidelity of public officers? They are infidelity in the custody of prisoners, infidelity in the custody of documents, revelation of secrets. This is from Article 223 to 230, and then there's another chapter after 230, so we will cover up to 245 actually, the last portion of the crimes committed by public officers. Infidelity in the custody of prisoners. What are the crimes under infidelity in the custody of prisoners? 1. Conniving with or consenting to evasion. 2nd, evasion through negligence. And 3rd, escape of prisoner under the custody of a person, not a public officer. So let's go to Article 223, conniving with or consenting to evasion. Any public officer who shall consent to the escape of a prisoner in his custody or charge shall be punished 1. By prison correctional in its medium and maximum periods, and temporary special disqualification in its maximum period to perpetual special disqualification if the fugitive shall have been sentenced by final judgment to any penalty. 2nd, by prison correctional in its minimum period and temporary special disqualification in case the fugitive shall not have been finally convicted but only held as detention prisoner for any crime or violation of law or municipal ordinance. So these are the elements, guys, that the offender is public officer. Basic yun, kaya under napamanta sa title crimes committed by public officers. 2nd, that he had in his custody or charge a prisoner, either detention prisoner or prisoner by final judgment. Magkaiba yan, detention prisoner and prisoner by final judgment. Itong detention prisoner, ito yung prisoner na ongoing pa ang case niya, or while the case is being processed or while the case is ongoing, he is to be detained if he has not posted a bail. Wala siya nakapost ng bail, then he is to be detained when the case is still ongoing. Ito namang prisoner by final judgment, tapos ng kaso, meron ng decision, and the decision has become final and executory, and he's now serving his sentence. Yun yung prisoner by final judgment. And the 3rd element is that such prisoner escaped from his custody. And the 4th, that he was in connivance with the prisoner in the latter's escape. So this is a guard, a prison guard, who was in his custody a prisoner or several prisoners, and he let the prisoner escape by conniving with him. Siguro binayaran siya or some kind of may gi-promise sa kanya na favor o baka kaya kaibigan niya, pinalabas niya, pinalayas niya. That's evasion, no? So Article 23 punishes any public officer who shall consent to the escape of a prisoner in his custody or charge. Connivance with a prisoner, this is connivance means the agreement between the prisoner and the public officer in his escape is an indispensable element of the offense. A policeman who allowed a prisoner under his guard to go and buy some cigarettes at a nearby store, thereby making possible the escape of the prisoner, is not in connivance with the latter, the policeman not knowing that he would escape. So iba yung may connivance, iba yung walang connivance. This particular example, the policeman here maybe committed some other crime, but not necessarily because of a crime under Article 223. Because the most important element here in Article 223 is that there is connivance between the prisoner and the policeman or the guard themselves. So classes of prisoners involved: if the fugitive has been sentenced by final judgment to any penalty, if the fugitive is held only as detention prisoner for any crime or violation of law or municipal ordinance. Article 224, evasion through negligence. Dito na siya naigo, evasion through negligence. Atong policeman ganina sa example, nga wala to connivance, pero papalit niya ang sigarilyo So wala siya mong tanaw, wala siya mong dahom. Pero nag-negligence siya diha nga dapita, no? So let's read Article 224, evasion through negligence. If the evasion of the prisoner shall have taken place through the negligence of the officer charged with a conveyance or custody of the escaping prisoner, said officer shall suffer the penalties of arresto mayor in its maximum period, to prison correctional in its minimum period and temporary special disqualification. Aning imprisonment dire nga prison correctional in its minimum to aresto mayor in its maximum period to prison correctional in its minimum period. Mao ni ang principal penalty sa officer under charge under Article 224. And this mention of a temporary special disqualification mo ni siya ang accessory penalty under Article 224. Automatic na si temporary special disqualification. Special disqualification is actually the person, the officer here, the public officer is not qualified to be in the public service again. But since it is temporary special disqualification, upon service of his principal penalties, mabalik na po to yung rights to serve as public officer. So these are the elements under 224. That the offender is a public officer that is charged with the conveyance or custody of a prisoner, either detention prisoner or prisoner by final judgment, that such prisoner escapes through his negligence. These are the example of infidelity through negligence. A policeman who assigned to guard a prisoner falls asleep with the result that the prisoner escapes is guilty of negligence in the custody of a prisoner. The guard in permitting the prisoner who later escaped to go to the nursery to gather gabi, considering that the place was grassy and all talahib was growing therein, was liable for infidelity in the custody of prisoners through negligence because the guard must have seen immediately that it was as it had been a choice place for any prisoner who may want to escape. Third, the accused contended that his order to the prisoner to keep close to him while he was answering the telephone call was sufficient precaution under the circumstances. The court said, untenable, the adequate precaution which should have been taken by him was to lock up the prisoner before answering the telephone call. Article 225, escape of prisoner under the custody of a person, not a public officer. Any private person, this one does not involve a public officer. But then, he has in his custody a prisoner. Siguro, again, trust sa iya, no? But let us read Article 225. Escape of prisoner under the custody of a person, not a public officer. Any private person to whom the conveyance or custody of a prisoner or person under arrest shall have been confided, who shall commit any of the offenses mentioned in the two preceding articles shall suffer the penalty next lower in degree than that prescribed to the public officer. So, lower, no? Lower ang degree, ana. Kung public officer, mas higher ang iyang penalty. Kung private officer, private person ka, mas lower ang penalty niya. Saka, aning mga example, aning private person, siguro karang masakpan ka ni sa masakpan sa, halimbawa sa mall. Wala ba, o pa may police na may mga security guard. So, i-detain sa nila. Ilang ipa-escape, liable ang security guard, no? Yun yung best example na makita ko, no? So, why in infidelity in the custody of prisoners committed by public officers, the code speaks of prisoner in the escape of prison under the custody of person not a public officer. The code mentions also person under arrest whose conveyance or custody must be confided to the offender. Article 225 is not applicable if a private person was the one who made the arrest and he consented to the escape of the person he arrested. So I stand corrected, no? When the when the guard at the mall arrested the person and then he later consented to the escape of that person, he's not liable under Article 225. But the difference is, may loon na po na to ang scenario, it's the police officer, siguro plainclothesman who apprehended the person shoplifting at the malls, no? And then giturned over niya sa security guard for processing. And then later on, para mo report pa sa iyang labaw, para i-turn over po sa presinto. Later on, the security guard let the person escape. This is when he commits violation under Article 225. Infidelity in the custody of documents. This time, wala na prisoner, no? What are the crimes under infidelity in the custody of documents? Removal, concealment, or destruction of documents, officer breaking seal, opening of closed documents. You know, when documents are in the custody of a government agency or government office, these are public property, government properties, and these documents must have to be taken care of under the custody. Dili basta-basta kay gobyerno, all the more na pagitaan ka ng accountability when you are in custody of documents owned by the public office. Pakitaan yung ka every now and then o kanang accounting ana imuhang documents under your custody. The documents as stated must have to be in the place where it is used to be. Dili siya pwede na maadto sa laing lugar nga dili siya authorized na maadto dito. Kung mabalin dito sa laing lugar, you could violate that particular provision of the law, no? So, yan. Let's read Article 226. Removal, concealment, or destruction of documents. Any public officer who shall remove, destroy, or conceal documents or papers officially entrusted to him shall suffer 1. The penalty of prison mayor and a fine not exceeding 1,000 pesos whenever serious damage shall have been caused thereby to a third party or to the public interest. 2. The penalty of prison correctional is minimum and medium period and a fine not exceeding 1,000 pesos whenever the damage goes to a third party or to the public interest shall not have been serious. In either case, the additional penalty of temporary special disqualification in its maximum period to perpetual special disqualification shall be imposed. The elements that the offender be a public officer, that he abstracts, destroys, or conceals documents or papers. The said documents or papers should have been entrusted to such public officer by reason of his office. That damage, whether serious or not, to a third party or to the public interest should have been caused. If any of these circumstances be not present, the crime disappears or rather does not arise. So tanawon ni sa mga lawyer kung kinsa tong defense counsel, isa-sound yun din siya inspect, no? Tanaw niya itong mga witnesses, public officer ba rin siya, gi-abstract ba rin siya, gi-destroy ba, gi-conceal ba ang documents, ba would have been entrust ba ng particular person or somebody in the office would have been entrusted to such document, because if he's not the one, then he has not committed any crime at all by reason of your office. And the last thing is that had there been damage to third party or to the public interest commensurate to the losing of the documents in the custody of the public officer, well, when you can prove this, na walang damage, then there is no commission of the crime. Acts punishable in infidelity in the custody of documents by removing, by destroying, by concealing documents or papers officially entrusted to the offending public officer. It is not necessary that the act of removal must be coupled with proof of intention to conceal. The word or is a disassociation independent of one thing from each of the other things mentioned, while in the interpretation of statutes or may be read and vice versa. It is so only when the context so requires. Accordingly, removal, destruction, and concealment must be viewed as distinct modes of committing the offense. Removal is for an illicit purpose when the intention of the offender is to tamper with it, or to profit by it, or to commit an act constituting a breach of trust in the official care thereof. The crime of removal of public document and breach of official trust is consummated upon its removal or secreting away from its usual place in the office, and after the offender had gone out and locked the door, it being immaterial whether he has or has not actually accomplished the illicit purpose for which he removes said document. Okay, the damage could be great or small. The fourth element exists whenever serious damage is caused thereby to a third party or to the public interest. Whenever the damage caused to a third party or to the public interest is not serious. Damage in this article may consist in mere alarm to the public or in the alienation of its confidence in any branch of the government service. Article 227, Officer breaking zeal. Any public officer charged with the custody of papers or properties sealed by proper authority who shall break the seal or permit them to be broken shall suffer the penalties of prison correctional in its minimum and medium periods, temporary special disqualification, and a fine not exceeding 2,000 pesos. Kung sa maning seal, what's the purpose of a seal? Kisa may naka-experience sa inyo kanang magpadala gani mo kwan, dalag package gani, tapos o parcel, tapos you would want it to enclose the parcel or to close the parcel or to seal the parcel in such a way that whenever there is tampering on the parcel, you would know. Kung naay mo tamper, mahibalaan mo na ang essence sa seal niya. Ang seal man god, na siya mga kind of impressions dito na pag i-tamper nimo na malaksiyo nimo na siya, dili sa madikit, ba ilham na nimo siya nga kuan malaksi. Kay laksiyo nimo siya, magisi na siya, and the person who would have received it after it being sent to you, Makita ang seal, uy, guba man yung seal. It could so kung guba ang seal, might be that the thing inside that particular envelope or box could have been tampered with by another person, because they are forcing the seal out. Mo na ang purpose sa seal, para kung maguba ang impression, the receiver of the parcel or the envelope would know that there is tampering on the parcel, or the content of the parcel might have been seen by anybody because the seal has already been tampered upon. Yun yung ka-importante ang seal, no, sa mga packages. So kaya kuidaw ka kung if you are in custody of parcels or documents or envelopes na may seal, bantayan mo talaga yan, kasi kung pag-inspection yan, lahat ng mga ka-seal na mga parcel dyan, sira lahat, you will be charged liable for it, no? Article 227, Officer Breaking Seal. Any public officer charged with the custody of papers or property sealed by proper authority who shall break the seals or permit them to be broken shall suffer the penalties of prison correctional in its minimum and medium periods, temporary special disqualification, and a fine not exceeding 2,000 pesos. So these are the elements that the offender is public officer, that he is charged with the custody of papers or property, that these papers or property are sealed by proper authority, that he breaks the seal or permits them to be broken. Maman ang purpose nga nang dili man gyud nimo matan-awan tong content dito sa sulod kung dili nimo i-break ang seal. Kailangan nimo i-break ang seal. Mo na ang purpose sa seal. Para mahibalaan nga naay tampering once the seal is broken. Where the documents are sealed by competent authorities, it is evident that the purpose thereof is to ensure its preservation. It is sufficient that the seal is broken even if the contents are not tampered with. Article 227 does not require that there be damage caused or that there be intent to cause damage. Even if there is no tampering on the contents of the boxes being sealed, the act of breaking the seal alone could cause you violating Article 227. Opening of closed documents. Any public officer not including the provisions of the next preceding article who without proper authority shall open or shall permit to be opened any closed papers, documents, or objects entrusted to his custody shall suffer the penalties of arresto mayor, temporary special disqualification, and a fine not exceeding 2,000 pesos. Unsa man ang purpose nga na i-close ang mga documents? The purpose is for confidentiality. So once na documents na close, you take it as a confidential, and if you have no authority to open it, do not open anything, no? Because if you do, you will be violating Article 228. Na. Meaning of word custody. The word custody means guarding or keeping safe, care. Those documents must be entrusted to the custody of the accused by reason of his office. 3 envelopes containing election returns and addressed to the provincial treasurer were handed by PC Sergeant to the municipal treasurer who put thereon sealing wax. Yan, sealing wax. Pag mag-break ng sealing wax, automatic na tampering na. The municipal treasurer was accused of opening the envelopes, taking out the election returns contained therein, and later returning them inside their respective envelopes. According to the court, the accused did not actually become the custodian of 3 envelopes turned over to him by the PC Sergeant and were delivered by the accused to said sergeant after having applied sealing wax to the same. The envelopes were not addressed to the accused, they were addressed to the provincial treasurer and were on the desk of the accused, just for the period of time necessary to put thereon the sealing wax. Under Article 228, the closed documents must be entrusted to the custody of the accused by reason of his office. Okay, damage. Article 228 does not require that there be damage or intent to cause damage. Enough na kung imong gi-open ang document, that would now make you in violation of Article 228. Revelation of secrets. What are the crimes under revelation of secrets by public officers? Revelation of secrets by an officer. Public officer revealing secrets of private individual. Murag kaning anggit-anggit lang sa espionage. Pero lahi tong espionage. Lahi pa ng revelation of secrets. But they have different penalties, no? Revelation of secrets by an officer. Any public officer who shall reveal any secret known to him by reason of his official capacity or shall wrongfully deliver papers or copies of papers of which he may have charge and which should not be published shall suffer the penalties of prison correctional in its medium and maximum periods. Perpetual special disqualification. 5 perpetual na yun, and a fine not exceeding 2,000 pesos if the revelation of such secrets or the delivery of such papers shall have caused serious damage to the public interest. Otherwise, the penalties of prison correctional in its minimum period, temporary special disqualification, and a fine not exceeding 500 pesos shall be imposed. So these are the elements of number 1. That the offender is public officer, that he knows of a secret by reason of his official capacity, that he reveals such secret without authority or justifiable reasons, that damage great or small because to the public interest. Sa elements na number 2, that the offender is public officer, that he has charge of papers, that those papers should not be published, that he delivers those papers or copies thereof to a third person, that the delivery is wrongful, that damage because to public interest. Remember, mentioned the damage because to public interest. Accordingly, if there is no damage to public interest, then there is no crime committed under this particular article. Article 230, public officer revealing secrets of private individual. Any public officer to whom the secrets of any private individual shall become known by reason of his office, who shall reveal such secrets, shall suffer the penalties of Aresto Mayor and a fine not exceeding 1,000 pesos. When the offender is an attorney at law or solicitor, Article 230 is not applicable. If the offender is an attorney at law or a solicitor, he reveals the secrets of his client learned by him in his professional capacity, he is not liable under this article but under Article 209. So, public officer, agad siya dapat, no? Kaya namin mga kuan po, like for example, kanang mga prosecutor or judges, o kanang mga clerk of court nga naadiha sa court. Pag naka-encounter silang sekreto anong tawhanan niya, i-reveal niya sa gawas, then he will be liable for this particular article. Kanimang gong attorney at law, solicitor, kanimang mga lawyer niya sa counsel niya sa mga parties, lahi po ang ilang violation ani. If they reveal the secrets of their clients, then they will be violating Article 209 instead of Article 230. Now let's go to other offenses or irregularities by public officers. Section 1, disobedience, refusal of assistance, and maltreatment of prisoners. Article 231, open disobedience. Any judicial or executive officer, judicial, mga personnel sa court, executive personnel sa mga government agency other than courts. Okay, any judicial or executive officer who shall openly refuse to execute the judgment, decision, or order of any superior authority made within the scope of the jurisdiction of the latter and issued with all the legal formalities shall suffer the penalties of Aresto Mayor in its medium period, to prison correctional in its minimum period, temporary special disqualification in its maximum period, and a fine not exceeding 1,000 pesos. Okay, a municipal secretary who openly refuses to deliver to the mayor, after having been repeatedly requested to do so, the keys of the doors of the municipal building and the seal under his custody, there is in this case an open refusal to obey an order. Mandamus by Supreme Court ordering lower court to receive certain evidence. If the lower court openly refuses to obey said judicial order, there's violation of this article. Mandamus is the order to do something, to do what is being required to do. Prohibition is the order not to do. If you do that, you are violating something. Yan yung prohibition as compared to mandamus. Mandamus is forcing you to do something. Prohibition is forcing you not to do something. Yan yung sa Supreme Court. And if you're ordered mandamus to, like in this particular case, the lower court is ordered by the Supreme Court to receive the evidence. Okay? And the lower court refuses to obey said judicial order, is in violation under Article 231, open disobedience. Disobedience to order of superior officer when said order was suspended by inferior officer. Any public officer who having for any reason suspended the execution of the orders of his superiors shall disobey such superiors after the latter have disapproved the suspension, shall suffer the penalties of prison correctional in its minimum and medium periods and perpetual special disqualification. That the offender is public officer, that an order is issued by his superior for execution, that he has for any reason suspended the execution of such order, that his superior disapproves the suspension of the execution of the order, that offender disobeys his superior despite the disapproval of the suspension. Manghod lang ni gamay sa kwan kaning nana sa private na kwan sa mga private companies. But sa private companies, once i-define mo ang order sa imong superior, you will be suspended in your work because you are in disobedience of the order of your superior. Pero pare-pareha po sa public office, lahi po nila kay nagay word nga disobedience. Pero dito sa private companies, lain to ang terminology nila ito, nakalimutan ko na. But there will be, ma-recall na ko, I will get back to this. Insubordination, by the way. That's insubordination sa private nga companies. Grabe lang insubordination. Masuspend yung ka na or pwede ko ma-terminate dito sa trabaho. Dire, basic, naka-state yun dire, disobedience, no? But dito sa private companies, employment, insubordination ang tawag. 233, refusal of assistance. The penalties of Aristo Mayor in its medium period to prison correctional in its minimum period, perpetual special disqualification and a fine not exceeding 1,000 pesos shall be imposed upon a public officer who, upon demand from competent authority, shall fail to lend his cooperation towards the administration of justice or other public service. If such failure shall result in serious damage to the public interest or to a third party, otherwise Aristo Mayor in its medium and maximum periods and a fine not exceeding 500 pesos shall be imposed. Naging imprisonment, Anyway, this imprisonment naman are, pwede ka mag-apply ng probation. Basta di mag-abot ng 6 years, no? Dili maglampas ng 6 years sa imprisonment nimo, pwede ka mag-apply ng probation. But nonetheless, if you are a public officer, if you commit even this petty crime naman ni Anigot, it's petty crime na kung mabahira yung public service for several years na kanilang petty crime, refusal of assistance lang ka, ma-charge ka na ani, you will be called ex-convict ani. So, even if you avail yourself with probation, nakamarka na imong service record dito sa public service din. Article 234, refusal to discharge elective office. Kani mga elective office, kani mga mayor, mga konsihal, mga barangay captain, congressman, governor, board members, councilor, senador, president, vice president. Yun yung mga elective office ha. So naging sila yung mga functions respectively. So if they refuse to discharge elective office, then they will be violating Article 234. The penalty of Aristo Mayor or a fine not exceeding 1,000 pesos or both shall be imposed upon any person who, having been elected by popular election to a public office, shall refuse without legal motive to be sworn in or to discharge the duties of said office. Hindi siya, resign na lang siya kaysa dili siya magpa-sworn in, no? Refusal without legal motive mo na dira ang sabot dia nga violation. The refusal must be without legal motive if the elected person is underage or otherwise disqualified. His refusal to be sworn in or to discharge the duties of the office is justified. The reason is that once an individual is elected to an office by the will of the people, the discharge of the duties of said office becomes a matter of duty, not only a right. So you have to discharge your duty. This Article 234 not applicable to appointive officer. Katong gipa-appoint, Secretary of Justice, Secretary of National Defense, moto. And down the line, this article penalizes refusal to discharge the duties of an elective office. Hence, refusal to discharge the duties of an appointive office is not covered by this article. Article 235, maltreatment of prisoners. Now, the penalty of prison correctional in its medium period to prison mayor in its minimum period, in addition to his liability for the physical injuries or damage caused, shall be imposed upon any public officer or employee who shall overdo himself in the correction or handling of a prisoner or detention prisoner under his charge by the imposition of punishments not authorized by the regulations or by inflicting such punishments in a cruel and humiliating manner. If the purpose of the maltreatment is to extort a confession or to obtain some information from the prisoner, the offender shall be punished by prison mayor in its minimum period to temporary special disqualification and a fine not exceeding 6,000 pesos in addition to his liability for the physical injuries or damage caused. Pero talang sarang ma-convict aning mga pulis kay wala may mo witness. Basta pulis na gani, kasagahan sa akong experience, no? O sa mga balitaan nato, basta pulis na gani maltreat of prisoner, wala mo witness eh. So how can you prove that he's being maltreated by the police officer? I had a client, no? Dakop sa iya, gidetain siya, and then he was being maltreated by policeman. andyan siya, bunog yun siya, kulata yun siya maayo. And after several days, after sa kulata, preso siya, saka pa siya gipa-doktor. Wala na tong mga traces sa kulata sa iya. But my client would really tell me that he was being tortured to siphon off some kind of incriminating evidence against him para patug-anon lang yun siya na siya nagbuhat sa ba. So we were contemplating to file charges against the policeman, but then again, wala man. Namang sa pesuhan akong kliyente niya, tapos ako mo witness sa iya. Siya lang mo himo affidavit, self-serving kaayo, tapos sa mga ubang mga priso dito nakakita sa pagkulata sa iya sa pulis, di man po mo testify, so wala ko'y mahimo. So yun. Tapos kapagkita po sila medical certificate nga wala siya gihilaptan, ang doktor po testify mo kuan mo po hatag mo po medical certificate nga wala tatsa ang prisoner, even if the prisoner has been mauled beforehand. Kaya ipaayo pa lang sa siya bago siya gipa-check up. May style sa mga police, no? It's really wrong, but then that's happening in our midst. There should be something mo ni mga balaoda nga makakorek unta na, but then again, dili man makorek, wala man kay witness laging mo testify nga gimaltreat ang prisoner. Wala bilang pulis ay imong kalaban, hadlok ka lang balikan sa pulis. So power ang mga pulis na mo in the future, you will know that you have the power in your hands, that you should be so conscious that you should not be abusing that power. Sana sa inyo ang power sa inyong mga kamot. Pag na-appoint ng police officers, lalo na mga investigators, beware, no? Ang power man good, pag nana sa inyo makahubog ba, it's so revitalizing that you would tend to abuse the power that it's in your hands. And then especially so if when you are newly hired na police officer and you would know that that particular practice, even if wrong, is already being implemented by your seniors, no? So what you have to do is to follow what they have been practicing all along. Yun yung mangyayari sa inyo dyan. So kung corrupt yung mga seniors nyo, sooner or later, it's possible that you will be corrupted in the long run after you are being exposed to their ways, no? Ito sa inyo ang makabaro ninyo. Remember me when you are already there. When you are already a police officer, remember me. If makonscious pa mo, if you would sense that you are already, your sense of morality has already been changed, change from being idealistic to becoming pira-pira lang yan. Yan, yun yung apa nila Yan yung expression nila. Pira-pira lang yan. Parang it's just not, parang walang, it doesn't matter after all. Pira-pira lang yan. Ayun yung masama doon. Parang meron na siyang, parang namimihasa sa Tagalog. But then in English, meron niyang tawag yan. Parang manhid na gani nga. So you could keep on doing this particular act because no one would dare punish them or apprehend them when you're doing it. So it's just like, ito na yung standard na ito So gawin na natin, effective naman siguro natin, although looking at it is really very wrong. Kaya lang nagiging practice na yan nila. Okay, let's go further. What do you think of officers abusing their powers? Okay lang ba yon na magiging practice na yon sa kanilang ginagawa everyday on their lives? Let's continue with our lesson. Section 2, Article 236, Anticipation of duties of a public office. Any person who shall assume the performance of the duties and powers of any public office or employment without first being sworn in or having given the bond required by law shall be suspended from such office or employment until he shall have complied with the respective formalities and shall be fined from 200 to 500 pesos. Kanina, ang ating discussion is when you are elected office, ayaw mo mapa-sworn in because you would not want to do the public duties entrusted to you as an elected officer. This time, you are not sworn to. This is anticipation of public office of any person who shall assume the performance of the duties and powers of any public office. This time, the duty na ka, you are so eager to do your job at that particular office, but then you have not yet been sworn in. Wala pa kag-sworn, wala pa ka nakasulat o ka ng mga certification or affidavit swearing hata o mag-post og band nga required by law naman ay mga accountable officer pa-post ng band So after swearing in, diretso siya trabaho, wala siya nag-post og band and then wala siya na sworn in. Unlike sa other one nga nag-refuse siya sworn in kaya dili siya mo trabaho, kasi siya di trabaho siya pero wala siya ka sworn in. This is another kind of mistake in going right away to the duty while you have not yet been sworn in. You have to be sworn in first because that's the formality required of you by the law. Balaod man nag-require ana nga i-formalize ko na siya by swearing in first and then post the necessary bond as a accountable public officer. So you have to do that first before you go on your duty. Otherwise, you will be violating Article 236. Okay, prolonging performance of duties and powers under Article 237. Any public officer who shall continue to exercise the duties and powers of his office, employment, or commission beyond the period provided by law, regulation, or special provisions applicable to the case shall suffer the penalties of prison, correctional in its minimum period, special temporary disqualification in its minimum period, and a fine not exceeding 500 pesos. Minsan, ka ng mga public officer, ganahan sa imong office, nakalimot na ka, o deadline naman dahil, hindi na ako pwede mag-work 3. Nga naman dahil kay term, no? Lampas na sa ka-term, nagtrabaho lang gyapon ka, you are now be violating under this article. Public officer who has been suspended, separated, declared average, or dismissed cannot continue to perform the duties of his office. Suspended ka, separated ka, declared overage. Overage? Sa may overage sa military or police office, lampas na ka sa edad nga pila retirement age sa police? 56. Article 238, abandonment of office or position. Any public officer who before the acceptance of his resignation shall abandon his office to the detriment of the public service shall suffer the penalty of arresto mayor. Nag-resign siya, diretso siya hawa. Pagani i-accept yung resignation. If such office shall have been abandoned in order to evade the discharge of the duties of preventing, prosecuting, or punishing any of the crimes falling within Title 1 and Chapter 1 of Title 3 of Book 2 of this Code, the offender shall be punished by prison correctional in its minimum and medium periods and by arresto mayor if the purpose of such abandonment is to evade the duty of preventing, prosecuting, or punishing any other crime. So there must be a written or formal resignation. One of the elements that the offender is public officer, that he formally resigns from his position, that this resignation has not yet been accepted, that he abandons his office to the detriment of the public service. A verbal statement made by the accused to the collector of internal review that he was resigning is not the form of resignation contemplated by the setup of our civil service system. Nakagin siya resignation letter, no? The resignation has to pass to various officials of the offices concerned for appropriate action. When accused was an employee of the Bureau of Internal Revenue and he was appointed therein by the department head concerned upon recommendation of the Collector of Internal Revenue. For this reason, no other official has to approve accused resignation but the one who appointed him, a power that is in adjunct to his appointing power. This goes to show that a written or formal resignation is indispensable to a resigning employee. You have to really write a letter, no, of resignation, and it has to be accepted before you leave your office behind, abandoning any of the pending duties and responsibilities therein. If the abandonment of the office has for its purpose to evade the discharge of the duties of preventing, prosecuting, or punishing any of the crimes falling within Title 1 and Chapter 1 of this Title 3 of Book 2 of this Code, the penalty is higher. So Title 1 and Chapter 1 of Title 3 of Book 2 of this Code refers to the crimes of, so could it be this particular person is in charge of preventing, prosecuting, or punishing any of the crimes. And these are the crimes: treason, 2. Conspiracy and proposal to commit treason, 3. Misprision of treason, 4. Espionage, 5. Inciting to war or giving motives for reprisal, 6. Violation of neutrality, 7. Correspondence with hostile country, flight to enemy country, 9. Piracy and mutiny, 10. Rebellion, 11. Coup d'etat, 12. Conspiracy and proposal to commit coup d'etat or rebellion, 13. Disloyalty of public officers, 14. Inciting to rebellion, 15. Sedition, 16. Conspiracy to commit sedition, and 17. Inciting to sedition. So if these are the duties na imong ginaiwan, then and you abandon it, even if your resignation has not yet been accepted, then you will be liable under this Article 238. Article 239, usurpation of powers and unlawful appointments. Article 239, usurpation of legislative powers. Legislative powers refer to the powers when you are under the legislative branch of the government. Mainly, ang pinaka-mention yun ng legislative powers is mainly based on the Congress and the Senate of the Philippines. pababa na sa board members, legislative powers na sila. And then pababa pagod na ang municipal council or city council. Ang mga legislative powers na sila. The offender is an executive or judicial officer. A public officer shall the penalties of prison correctional is minimum period, temporary special disqualification, and a fine not exceeding 1,000 pesos shall be imposed upon any public officer who shall encroach upon the powers of the legislative branch of the government, either by making general rules or regulations beyond the scope of his authority, or by attempting to repeal or a law or suspending the execution thereof. So you are not a legislative officer, you are not a congressman, you are not a senator, you are not a board member, you are not a councilor, and then you make such laws usurping the powers of the legislative branch, then you will be violating under Article 2339. You are in violation of Article 239, usurpation of legislative powers. You are making general rules or regulations beyond the scope of your authority, and you attempt to repeal a law or suspend the execution of such law. Article 240, usurpation of executive function. This time, it's the executive functions na naman, no? Like, you are in the legislative branch and judicial branch, and then you usurp the function of the executive, like the mayor, the governor, the president. You are usurping the executive functions. Any judge who shall assume any power pertaining to the executive authorities or shall obstruct the latter in the lawful exercise of their powers shall suffer the penalty of arresto mayor in its medium period to prison correctional in its minimum period. So, judge ang makabiolate ani. The offender is a judge that he assumes a power pertaining to the executive authorities or obstructs the executive authorities in the lawful exercise of their powers. Now, this time, usurpation of judicial functions. Function na po sa judiciary ang usurp, no? The penalty of arresto mayor in its medium period to prison correctional in its minimum period shall be imposed upon any officer of the executive branch of the government who shall assume judicial powers or shall obstruct the execution of any order or decision rendered by any judge within this jurisdiction. Unfair, so wala ba legislative function, no? Wala na violation din sa kuan. Well, kung usurpation sa legislative function ang nakabiolate ang katong executive o judicial officers, while usurpation sa executive functions o judicial function, wala gimension ang legislative officers, no? May unfairness po din, no? Sa observation na nako, the penalty of arresto mayor in its medium period to prison correctional in its minimum period shall be imposed upon any officer of the executive branch of the government who shall assume judicial powers or shall obstruct the execution of any order or decision rendered by a judge within his jurisdiction. Wala gyud judicial branch of the government diri nakabiolate. Yon, na-notice ninyo? Mayor is guilty under this article if he investigates a case while justice of the peace is in the municipality. Articles 239 to 241 punish interference by officers of one of the three departments of the government with functions of officers of another department. Article 239 to 241 punish interference by the officers of one of the three departments of the government, legislative, executive, and judiciary, with the functions of the officers of another department. The purpose is to maintain the separation and independence of the three departments of the government and to keep the three branches within the legitimate confines of their respective jurisdictions and the officers thereof within the scope of their lawful authority. Article 242, disobeying requests for disqualification. Any public officer who, before the question of jurisdiction is decided, shall continue any proceeding after having been lawfully required to refrain from so doing, shall be punished by arresto mayor and fine not exceeding 500 pesos. So, any public officer na makabiolate ani. But then, there's a question of jurisdiction, and once decided, proceed siya. Kanang namang may question sa jurisdiction, na proceedings karon, no? Either sa judge or sa mayor, whatever, executive officer, judicial branch, or sa legislative branch, ongoing ang proceedings, but then again, the proponents there petition to higher ups, to the courts, maybe, on the jurisdiction of that proceedings. Allowed ba na siya? Lack of jurisdiction man na. There's a question of lack of jurisdiction, no? While this question of lack of jurisdiction, or there's lack of jurisdiction, on the impropriety of the proceedings being rendered, is hanging, is still ongoing, nagpadayon ng yapon ka, bisag napay question, dapat imo na i-post, suspend mo na ang proceedings until after the question as to whether you have jurisdiction to continue with the proceedings or not shall have been decided, no? Kung wala pa naman decided na ikuha sa nimo, imo sa i-post, suspend sa nimo ang proceedings nimo while awaiting on the decision higher ups telling you that you have jurisdiction. If you have jurisdiction, you continue. If you don't have jurisdiction, you stop the proceedings entirely, and then, well, if proper, you transfer the proceedings to the proper agency with sub-jurisdiction over the matter. Ganun yun eh. That's Article 242. Article 243, orders or requests by executive officers to any judicial authority. Any executive officer who shall address any order or suggestion to any judicial authority with respect to any case or business coming within the exclusive jurisdiction of the courts of justice shall suffer the penalty of arresto mayor and a fine not exceeding 500 pesos. Kaya mga mayor man god, ba-inquire, Judge, ay lang sana, padayon na Judge. Kung sana, ana ba? What's na order or request ang tawag ha? Order meaning na yun siya formal letter. Ordering the judge to refrain from prosecuting the case. Ana ba? This is actually akin to tampering or interfering with the function of the judge, which is a separate branch of the government than that of the executive. Kailangan may delineation talaga ang function ng executive at saka judge. You don't interfere with others. Article 243. Article 244, unlawful appointments. Any public officer who shall knowingly nominate or appoint to any public office any person lacking the legal qualifications therefore shall suffer the penalty of arresto mayor and a fine not exceeding 1,000 pesos. That's Article 244, unlawful appointments. That the offender is a public officer, that he nominates or appoints a person to a public office, that such person lacks the legal qualifications, therefore, that the offender knows that his nominee or appointee lacks the qualifications at the time he made the nomination or appointment. Wala may na kasuhan ani nga criminal offense. Wala pa ko kadungog ani na kasuhan ani. Article 245, abuses against chastity. Kani antimanaan sa mga officers, labi na kanang mga lalaki ng mga chick boy diha kamo, mga boys ha, mga chick boy mo ha. Ano yung mga sakit sa uban mga police officers nga nangabuso. Dahil mga na prison na ani. Dahil mga na media na ani nga police officers na naabuso sa ilang mga contemporary katong mga subordinates or mga priso giabusuhan, no? So under this particular section 4, this is under the title abuses against chastity. Article 245, abuses against chastity, penalties. The penalties of prison correctional is medium and maximum periods and temporary special disqualification shall be imposed upon any public officer who shall solicit or make immoral or indecent advances to a woman interested in matters pending before such officer for decision. Ma'am, pwede na ito ni basta ano na, balo na mo, or with respect to which he is required to submit a report to or consult with a superior officer. Now, any public officer, makasalaan niya. Second, any warden or other public officer directly charged with the care and custody of prisoners or persons under arrest who shall solicit or make immoral or indecent advances to a woman under his custody. Kasagaran mga woman under his custody ani madakpan mga estapador, ng mga gwapa nga mga babae. Ayun, ka-interest ang mga officer nga under ani. Muna ilang ko ano. Daghantang nadungog sa media nga inaani nahitabo, no? But I hope karon mawala na ni klase nga abuso under you when you become police officers, boys, guys. Remember this dili mo mga abusar kay naman mo yung choice na mag-asawa sa inyong asawa ninyo buhaton sa inyong uyab. Ayaw mo pag interest sa lain nga labi na ka nang nasa advantage nyo kay nasa inyong care, nasa inyong custody, so dali lang kayo nimo makuan ba ang imuhang undue advantage over the prisoner. Dili lang kayo makahangyo o maka-demand, no? If the person solicited to be the wife, daughter, sister, or relative with the same degree by affinity of any person in the custody of such warden or officer, the penalties, ito mga bisita, no? The penalties shall be prison correctional in its minimum and medium periods and temporary special disqualification. Wife, daughter, sister, or relative within the same degree by affinity. Sister-in-law, daughter-in-law, mga relative by within same degree. Natawag din siya abuses against chastity. So, pasabot sa solicit. Solicit means to propose earnestly and persistently something unchaste and immoral to a woman. Okay, the advances must be immoral or indecent. And note that the law uses the words immoral or indecent advances. The crime of abuse against chastity is consummated by mere proposal. Ano mo gud miss? Ano mo good? Lisod man kayo ni kuanon, pero pwede naman gyapon pakita ng paagi, pero nala koy condition ani. Wala na ka say condition ha. Yon mga offense against abuses against chastity.